It's 10 Eastern, 7 a.m. Pacific. I'm Ana Cabrera reporting from New York. Let's get right to that breaking news. Just moments ago, a federal judge denying the Justice Department's bid to unseal grand jury records from the criminal case against Ghislaine Maxwell, Epstein's accomplice, noting in part that the materials do not identify anyone other than Epstein or Maxwell who had sexual contact with a minor. And joining us now for more on this is MSNBC's Ken Dilanian and former federal prosecutor Barrett Berger. So, Ken, break this down for us. What are we hearing from this judge?
This was a resounding ruling, Anna, totally repudiating the Justice Department's request to unseal these transcripts, really saying that there are no special circumstances here and it's not in the public interest to violate grand jury secrecy by throwing this stuff out to the public, in part because the judge said these materials would reveal nothing new. They're basically a summary of things that are already in the public record from the trial of Ghislaine Maxwell. I'll just read from one of the passages here. A member of the public familiar with the Maxwell trial record, the judge wrote, who reviewed these grand jury materials would learn next to nothing new. He said they do not reveal new venues at which their crimes occurred. They do not reveal new sources of their wealth. He's talking about Epstein and Maxwell. They do not explore the circumstances of Epstein's death, and they do not reveal the path of the government investigation. He further said there's no client list in here. There, as you said, there's no allegation that anyone else had sexual contact with minors. And he is saying that really the only decent legal argument to release these transcripts, this was remarkable, is that it would show that the Justice Department's argument for doing so was totally disingenuous and may have been more about distraction than transparency. Those are the words of a federal judge, Anna.
And so, Bear, what's your reaction to this?
I'm not surprised by this, Anna. It is a very high threshold to unseal grand jury materials for good reason. We make this promise to witnesses that testify in the grand jury that these are secret proceedings. And so it really has to be a high public need for these kinds of documents to become public. The judge here very clearly found there was not. The public being interested in the story just doesn't meet what the statute requires. What's interesting to me is that a lot of the arguments that DOJ made at the end about why these documents should be released, the judge actually seemed to say support them not being released. DOJ was saying much of this material was already made public during trial, so really what's the harm of releasing it? The judge flipping that right back saying, actually, because this material was largely made public during a very lengthy trial, now there is no need to take this extraordinary step of unsealing these records. So it's not surprising, but I'm sure for many people it will be disappointing.
Yeah, one of the things that stood out in this ruling, as we continue to read through this on page 21, so it's a lengthy ruling, he writes of the Maxwell grand jury testimony that this is not a matter of significant historical or public interest. Far from it. It consists of garden variety summary testimony by two law enforcement agents, and the information it contains is already almost entirely a matter of long-standing public record. I mean, Barrett, wouldn't the DOJ have already known this when they asked to have these transcripts made public?
They would. They would have obviously reviewed these documents. And that's what many of us who worked as federal prosecutors have been saying. Grand jury proceedings, by and large, are not as, sexy as many people may think they are. Usually it's not hundreds of witnesses that are testifying for the grand jury. It's one, maybe two case agents that testify, often putting in, large summaries of documents that they've reviewed or people that they've spoken to. Hearsay testimony is allowed in the grand jury, so that's why federal prosecutors are often able to only call one or two case agents as their witnesses. So the federal prosecutors here would have certainly reviewed these documents. They knew what was in them. Again, this may be some type of, trying to serve the client here, saying the client really wants these to be public and we're getting a lot of pressure, so let's make the motion. But definitely they would have known the substance and known that there wasn't anything so groundbreaking in them.
And so, Ken, we know there's a separate judge considering unsealing documents as well. Could that still happen?
Look, there's every reason to believe that this judge, the judge in the Epstein case, who's considering a similar request, will come to the exact same conclusions, because that was also a summary witness grand jury. Neither of these were investigative grand juries where they called witnesses. These were, again, this was an FBI agent going for one day and explaining to the grand jury why there was probable cause to believe a crime was committed, why they should return an indictment. Look, to the extent that there is interesting or titillating information in the FBI files in the Epstein case, they're probably not in this grand jury material. They may still be buried in FBI files somewhere. Things like, files with Donald Trump's name on them or other people's names on them. But like the FBI gathers a vast amount of material in a criminal investigation, and it stays secret for a reason. It is really invasive of people's privacy. It makes unsupported allegations that were never aired in court. That's why it's secret. So the idea that the government would air all that out to satisfy conspiracy theories about that unfounded about the Epstein case, I just don't see that happening at the moment.
And of course, we don't want to forget all of the abuse survivors who also weighed in wanting some of these transcripts and records to be unsealed. And the judge writes about that, Barrett. The victim's interest in reviewing the grand jury materials appears to be premised on the understandable but mistaken belief that these materials would reveal new information. Had the government's motion made clear that these records are redundant of the evidence at Maxwell's public trial, the victim's responses to the motion to unseal might well have been different. So, as we've discussed, this is not unexpected necessarily, since it was just these two witnesses who would be involved in the transcript specifically. But Barrett, what about the other exhibits that were presented to these grand juries? Other documents, police files, interviews, recordings? Could that still be revelatory?
It could be. The judge seems to think that's unlikely. But, Anna, the judge points out something that I think gets lost in a lot of these discussions, which is, this has been so traumatic for the victims from day one, not only based on everything they went through, but having to live through a trial and now having all of this information essentially relitigated and brought back up. The victims here very often not getting a clear story about, what they're entitled to, what could be in there. So it's this real series of ups and downs, them thinking, maybe we'll learn something new, maybe we won't. What's missing here is any sense of closure for these victims. That's one of the reasons why grand jury proceedings, are so difficult to get unsealed. It's one of the reasons why we have finality in court proceedings, because there should be some type of closure and ending for victims. The victims in this case certainly have not gotten anything close to that yet.